This case, decided in the English Court of Appeal in 1948, is a classic administrative law case, more often misunderstood than used properly. The case involved a cinema in the town of Wednesbury. Back then they were very serious about ensuring that businesses did not trade on Sundays, not without special permission. Now obviously Sunday is a great day for a cinema to be trading because people are off work. The cinema applied to the local council for Sunday trading permission, and the local council agreed, but they imposed a condition that no person under the age of 15 may attend the cinema on Sundays, not even if they were accompanied by an adult. Naturally, the cinema was less than impressed with this decision, and they sought to have it reviewed by the court. Their argument was that the council did not have the power to make that decision. It was ultra vires. The difficulty that stood in their way was that the statute said that the council could grant permission subject to such conditions as the authority thinks fit to propose. That's a pretty broad power. The cinema argued that the council had to use that power reasonably, and that if it did not do so, then the power was being used unlawfully. Now the court straight up agreed that the power had to be used reasonably, but the next question was what is meant by reasonableness. The bar had to be set pretty high because it was a well understood principle of law that the courts would not simply review the merits of an administrative decision. So the argument had to be something more than simply complaining that the council had got the decision wrong. Lord Green, Master of the Rolls, explained the principle. He said the court could interfere if a decision-making authority had come to a conclusion so unreasonable that no reasonable authority could ever have come to it. This is a very high bar. So unreasonable that no reasonable authority could ever have come to it. It therefore really needs to be outrageous. So for instance, if the Wednesbury Council had allowed Sunday trading but only for customers whose name started with A, that would have been unreasonable. In this case, the purpose of preventing children from being diverted from church was not considered sufficiently unreasonable, and the council's condition was valid.